Hey Dave, can you hear us? Sorry. Hey Dave, can you hear us? I can't hear you though. Oh, can you switch the I'm sorry. Can you switch the thing? Sorry. Hey Dave, can you try again? Sorry.
Hey.
Yeah, we can hear you now. Thank you.
Okay, thank you.
Oh yeah, no, I know.
Okay, welcome to the Public Service Commission's administrative meeting for March 27th, 2024. Before we get into the official business, I just want to make a couple comments about the tragic accident yesterday. As some of you may know, I mean, this commission actually has some involvement in the industries with that. We rate regulate the Maryland pilots, and obviously we're, saddened by the loss of life of the folks that were on the bridge, got trapped on the bridge, literally doing their jobs. But I do want to mention that, based on what I've read so far, that the pilot and pilots, I guess, that were involved in this actually did their job. And we actually took a trip to, when we first came on board, to talk to the Maryland Pilot Association, and they showed us, the work they do, and part of it was a trip to the port, so we got a chance to look at ships like the one involved in the incident yesterday up close and personal, but I'm glad to see that the pilot did his job in what I guess was an extreme situation, and prevented the tragedy from being even any worse by the efforts that they took. So we want to take a pause for the families that suffered apparently a loss of life from it, and obviously this commission will do whatever it needs to do to help facilitate getting the port back in business, and whatever efforts the state takes to resolve the traffic dilemmas and the infrastructure going forward. So with that, we have minutes from our meeting of March 13th, 2024. Commissioner Sussman.
And if the chair can indulge me for just a minute, in addition to the pilots, I think we're going to learn a lot over the next couple of days about the heroes that participated in this. It was kind of an unbelievable exercise of judgment and speed that they were able to shut down the bridge, and so we're not thinking now about all of the things that could have been done.
Sure.
And so my heart goes out to the people who have families that have lost lives, but my heart is also full from the heroes that we've seen so far and will see in the next couple of days. So with that, aye.
Commissioner Barbay.
Well, what the heck? I'm going
Go
to
ahead,
make
yeah.
a comment. Many times in my committee, we oversaw the port, and sometimes questions were asked about the number of police officers who were sitting around doing nothing. And we now know how valuable that is. There are many lives that were saved, and with that, Mr. Chairman, I vote aye.
Commissioner Richard.
And I agree with everything that's been said, aye.
And I vote aye. So, Mr. Secretary.
Morning, Mr. Chair. There are 5 items on today's consent agenda. Item number 1 is revised tariff pages from Verizon Maryland LLC. Item number 2 is a request from Starlink Services LLC to relinquish its eligible telecommunications carrier designation. Item number 3 and 4 consist of revised tariff pages from Global Crossing Local Services, Inc. And finally, item number 5 is a request to surrender authorization for Electric Lightwave LLC from Zia Group LLC and Electric Lightwave LLC.
Okay, regarding item 1, I move that we accept the tariff revisions for filing with an effective date of April 1, 2024. Commissioner Sussman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 2, I move that we cancel the company's designation as an eligible telecommunications carrier in Maryland without prejudice, effective March 20, 2024. Commissioner Sussman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Regarding items 3 and 4, I move that we accept the tariff revisions for filing with an effective date of April 1, 2024. Commissioner Sussman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
And regarding item 5, I move that we note the consolidation of Electric Lightwave LLC into the Zayo Group LLC on December 31st, 2023, and accept the surrender of authority for Electric Lightwave LLC to provide resold interexchange services effective January 1, 2024. Commissioner Sussman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 6 on today's administrative agenda is a request from Maverick One LLC for an extension of the operational deadline for its solar project in Carroll County.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. Item 6 is a filing by Maverick One LLC for a 12-month extension of the operational deadline for its community solar energy generating system located in Carroll County due to delays in the local permitting process for the project. Under Commission regulations at Comar 20.62.03.04C2, an electric company is to remove a project from its interconnection queue for projects in the pilot program if the pilot fails to begin operation within 36 months after its application. Comar 20.62.01.04, however, authorizes the Commission to waive a regulation in that subtitle for good cause shown. In its filing, Maverick One notes that the local government permitting process has delayed its construction with approval of the site plan taking nearly 24 months. Here, a waiver of the regulation specifying a 36-month operational deadline would be appropriate given that the project schedule delays have been largely caused by factors outside the control of the applicant. Furthermore, granting the requested waiver would be consistent with state policy granting or supporting the development of community solar energy generating systems to provide electricity to low and moderate income ratepayers, and of the renewable energy portfolio standard, which includes a 7% solar energy requirement for 2024. Staff recommends that the Commission grant the waiver requested by the company and extend the operational deadline for Maverick One Community Solar Energy Generating System from March 9, 2024 to March 9, 2025.
Okay, any questions for staff?
Just
Oh, go ahead.
just a quick question. Do you have a sense of where the project is in terms of the approvals for the project from Carroll County?
Well, actually,
Or is this going to be, you don't know?
Yeah.
So this is going to be a question for,
Yeah, probably.
and will you answer my question?
Yes, Commissioner.
Thank you.
Morning, Mr. Chairman and Commissioners. Max Cook on behalf of Maverick One LLC. I also have with me Mr. John Shields from the project company. We've reviewed staff's filing. We have nothing further to add. With respect to where the project is in the local permitting process, it finally did receive that site plan approval. We're now finalizing public works agreements with the county, decommissioning final items before we plan to receive notice to proceed in the next month or so.
And do you anticipate any further delays?
We don't, Commissioner.
Okay, thank you.
Any other?
Yeah, thank you, Mr. Chairman. So is this length of delay typical, longer than usual? How would you assess that?
As you've seen, Commissioner, each county is a little bit different. I think this one is on the longer side of these delays. A unique piece of this project is that it's both in the town of Manchester and Carroll County, so it's subject to some approvals from the town, along with Carroll County itself, and Carroll County does have a relatively long approval process.
Okay, thank you.
Well, actually, let me ask one question. Not to put you on the spot, but is this an instance where the county has been intentionally slow walking this process, or is this just part and parcel of how they do stuff?
I don't get the impression that this is the county slow walking the process. It is a thorough process, and there are a large number of agencies. I think in the filing indicates about 15 or 18 agencies have to conduct their own individual approvals, so I think that's the largest contributor here.
Oh. Okay. I didn't realize Carroll County had such bureaucracy, so. All right, with that, I move that we grant the waiver requested by the company and extend the operational deadline for the Maverick One Community Solar Energy Generation System from March 9, 2024 to March 9, 2025. Commissioner Schlesman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And the final item on the agenda is item number 7. It's a tariff filing from Potomac Electric Power Company.
Good morning, Chair and Commissioners. David Hoppock on behalf of staff. On March 4th, 2024, PEPCO filed 3 sets of rates associated with PEPCO's rate case filing in case number 9702 and the settlement agreement extending the procedural schedule in case 9702. 1, the proposed distribution charges in case 9702. 2, the proposed economic relief and recovery rider rates in case 9702. And 3, the revenue deferral mechanism rider rates and tariff language from the settlement agreement in case 9702 that fully offset the case 9702 rates such that the rate year 3 rates that were established in case 9655 will continue to be the effective rates billed from April 1, 2024 through June 30th, 2024. This filing implements the settlement agreement in case 9702 that the Commission approved in Order 90792 that extended the procedural schedule in case 9702 by 90 days. Staff confirms that the revenue deferral mechanism rider rates and tariff are identical to the revenue deferral mechanism rider submitted as part of the settlement agreement, and that this fully offsets the proposed rate change for the period from April 1, 2024 through June 30th, 2024, such that customers will be billed and pay the current case 9655 distribution rates during this 3-month period. Staff recommends that the Commission accept the proposed tariff for filing with an effective date of April 1, 2024. Staff is available for questions.
So, any questions for staff? Okay, Ms. Curry, go ahead.
Hello, Kim Curry, representing PEPCO. I have nothing to add.
I see. Any questions for the company? All right, seeing none.
I guess
Oh,
I would just ask,
okay.
note, and I would just take note that OPC hasn't filed anything on this particular item, so my presumption, of course, is that they're in agreement with staff. That's if that's not correct, then maybe they can correct that, but otherwise, that's my presumption right now. Thank you, Mr. Chair.
And just to be clear, so this is essentially implementing decisions that were made based on the settlement regarding the schedule in the rate case, correct?
That is correct.
Okay. All right, with that, I move we accept the tariffs for filing with an effective date of April 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, that concludes the administrative meeting for today. For those folks that are here for the 2 other matters, the cybersecurity rulemaking and the solar proceeding, we'll be doing those directly. So we'll first take the rulemaking on the solar issues, and then secondly, we'll follow with the cybersecurity regs. So, yeah, so I guess anyone who is directly involved in the 9720 proceeding, come up to the table. So. Yeah, oh yeah, we're gonna do that, yeah. Yep. Don't worry.
Charlie's gonna speak as well, but we can move around. Why don't you try? You need to. We can just.
All right, so for anyone who is planning to speak, why don't you introduce yourselves and so the court reporter can get your name for the record. So.
Good morning, Chairman Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of TPE MDPR 53 LLC. I'm joined by Salar Naini and Caroline Belmont from Turning Point Energy, the parent company of TPE MDPR 53. And appreciate the opportunity to join today.
Thank you, Chair Hoover, Commissioners. David Bugelmans on behalf of the Coalition for Community Solar Access. I'm also joined this morning by the Mid-Atlantic Director for CCSA, Mr. Charlie Kogashal, to my left here.
Good morning, Chair Hoover and members of the Commission, Annette Garofalo, and with Philip Vanderheyden and Paige Shaw on behalf of Commission staff.
Okay. Anybody else who plans on talking in this? All right, so
Thank you.
go right ahead.
Your Honor, in compliance with Commission's Order Number 90999, in case number 9720, staff filed its comments regarding the subscriber organization application process, both now and for the permanent community solar program, and the use and the means to allow large projects to apply for electric company interconnection prior to the start of the permanent program. Staff retains its position that the current application process by which the application is made, first with the Commission for authorization to participate in the program, after which it proceeds to the relevant utility to request interconnection and project capacity, should remain. This process was developed with stakeholders in the Commission and with Commission oversight, and has been an orderly one, offering protection to developers and customers alike in keeping with the Commission's original direction. Provision of electricity through privately owned community solar energy generating systems involves expense and creates costs to all affected parties, the utility and the electric customer, as well as the community solar developer and operator. And for this reason, it's important that all parties are considered when decisions are made. In addition, it should be noted that regulations that would govern the permanent program were filed with the Commission this week. These regulations were the product of considerable review and discussion by many of the parties filing responses to your order in this case. Many of the questions raised by the Commission's order in this case, and even by the comments of the parties here today, have been addressed in the rules proposed to you by the Net Metering Working Group. While not all represent a consensus of the Net Metering Working Group members, the proposed rules and included alternatives provide an opportunity to consider concrete language through which the Commission can provide clear direction. This approach has operated successfully since the inception of the Community Solar Program. Staff sees the majority of the issues raised in the instant proceeding as interrelated and in many cases dependent on the same policy and technical considerations. We recommend that considerations of net metering and community solar policy be maintained in the existing Net Metering Working Group forum in order to maintain continuity and leverage personnel resources. Mr. Vanderheyden has some additional brief comments, and Ms. Shaw is available for any questions you may have.
Okay, go ahead.
Good morning, Mr. Chair and Commissioners. I'm Philip Vanderheyden on the technical staff, and I'm the working group leader for the Net Metering Working Group. We just filed those regulations this week and look forward to having that discussion. I just want to briefly respond to a couple of the issues that came up in some of the comments from the other parties that in response to the order. Staff, we filed our comments and we stand by everything in there as Ms. Garofalo just indicated. One of the points is that it seems to be a major concern is the ability of large projects that would qualify under the permanent program, so things bigger than 2 megawatts up to the 5 megawatt, that they cannot proceed to interconnection at this point, and there has been a request to waive the co-location rules in 2062-03-08. That is the solution to that. We actually have looked at that, and those rules don't actually address the interconnection queues at all. The interconnection process and the sort of the procedure where we control the flow to those is entirely within a process that was mutually developed with the working group throughout the course of the program and was reviewed by the Commission at the beginning. So we do not think that an actual waiver is required. If the Commission desires to sort of shift how we're handling those projects and let the large projects go forward, staff believes we can simply alter the process by which those large projects are considered such that they can go through to the utilities interconnection queue without having received full acceptance into the program, which isn't possible
until those new regs are adopted and the commission's, it would be out of compliance with the commission's recent order in TPE. But we think we can solve that. There are some considerations. We have not really heard from the utilities as to whether or not all of them are capable of or want to take on beginning to handle those large interconnections at this point. So that's probably something we should hear from them as well. And then there are potentially winners and losers by letting some of those large projects move forward now without necessarily informing the entire development community that, hey, we're going to let these projects go into interconnection. And the concern there is once a project is in the interconnection queue and passes through that, there's sort of you sort of have a claim to the export capacity of the distribution feeder, and there may be some winners and losers if large projects sort of proceed now, and maybe others who were waiting for the beginning of the program. There may be some disadvantages there. Staff, I don't think we have a full idea of whether or not there will be folks that are affected by that. I have, heard from smaller developers that there are some concerns about the way the capacity will be allocated in this way. But we believe that it's merely, if the commission directs the staff to do it, we can change the approach we're using, allow those projects to go through. And we don't think it actually requires a waiver, and certainly not of the waiver that's been asked for in 2062-03. So just one or two other items. As mentioned, we do have RM56 in front of you. We will, a number of the issues that have been raised, in particular, some of those raised by, I think, the utilities regarding the application process, their role within it, staff's role within it. There have been some regulations proposed to specifically change that. That's some of the alternative language that's in the document that we sent to you. So you will have the opportunity to see what that language looks like and consider that. So it may be helpful to be thinking of this issue along with what has been proposed. And so there's another opportunity to handle some of that coming up, hopefully in the next month or so. There has been a request. I think CCSA was trying to be helpful by suggesting that we establish other working groups to handle things like the application process, the bonding, and issues relating to managing our 3,000 megawatt statewide cap. Staff is, appreciates that, but I don't know that creating additional working groups would be particularly helpful for us. We think that there's many of the issues are entirely interrelated, especially issues like bonding and the application process. We'll be looking at consolidated billing for community solar and in the sort of the subsequent rulemaking that we have to complete by the middle of 2026. So it wouldn't necessarily help us to spread that issue out into another or several other working groups. So I think we would like to keep that in the existing process, and it'll be more efficient, at least from our standpoint. And lastly, there have been issues raised as to the level of the bonding, the way that's being applied in the application process. And there's some perhaps thought that this was not governed by anything in the rules or the law, but folks will remember that the commission issued a letter order at the beginning of the program where it's a lengthy letter order where they sort of give their opinions on a number of the issues that had been raised to them. The current level of bonding, the way we operate, was set by the commission in that order. It was not what staff proposed. It was something that the commission themselves sort of made. I don't know if it was based on recommendations from other parties in the working group or not, but that's part of the commission's order in that regard. The approach that we are using with the application process is sort of it's a sequential or a serial. We address the applications as they come into us. That is how the interconnection queues are handled at each utility. That's done for fairness to each applicant. Even now, there is still a benefit to doing that, and so, to the extent that there are delays, some of that is caused by our review of the process, and in some cases, materials are not complete, and we have to send those back. We have not chosen to say, hey, we're going to reject your application, take it back, and then get back in line. So we could certainly change all of those things in the application process. And if that is the case, then folks that aren't complete would wait for some time. Something that I believe that will really help us going forward is we have proposed rules We have tried to, using our experience, really nail down what sort of applications are applicable in any situation that we could think of using, what we've learned thus far, so that hopefully no application will be held up because there's some ambiguity in the correct application of the law or the regulations. So, once we have those regulations in place, as we go through this rulemaking coming up, hopefully you'll see that we've tried to really sort of nail it all down so that it's very clear what is and what is not allowed, even in areas where perhaps the law left some ambiguity as to what that is. I think the regulations can be used to lock that down, and we think that will help going forward with managing the application process. So I think what we're generally saying here is the application process was developed over some period of time with a lot of input. It did have commission oversight when it was established, and we believe that we're prepared to manage this going forward, but would sort of hold off on making some changes until you have a rulemaking and you have all of those details sort of laid out in rules, with everyone's opportunity to comment on those specifically. And I'm certainly available for any questions you may have. Thank you.
So, any questions for staff? Commissioner Schlichtman.
Okay, so I guess I'll start now, and I probably could wait until the other parties have a chance, but I guess I'll start. So I'm a little confused, Mr. Van Hayden, by this this proposal you have to move large projects to the queue if the regulations prohibit co-locating projects. So you have projects that can't meet the conditions of the existing regulations. I'm trying to understand how you would take that project and then move it over to the interconnection side.
Okay, certainly. I'd love to answer
Please.
that question, and I wasn't particularly. There are two queues you need to be thinking about. There's the interconnection queue, and that's community solar and rooftop solar and any other solar project, any other interconnected generator that the utility takes through that process. That's a queue that has always existed as long as they've been doing that and will continue to exist unchanged by this. Our regulations don't actually talk about the interconnection queue. The queue that's mentioned in the law and in our regulations is the project queue. So to get into the project queue, which creates your wait list for projects that can't build because there wasn't capacity in the particular year or in the category in the program. So the bottleneck that has been sort of raised as an issue is the interconnection queue. Our regulations do not address that specifically, and I think we have sort of procedurally determined that it would be the best process to accept applications, authorize the SO, make sure they have, to go through the process of identifying the company and and making sure they have all of the financial and management technical credentials before they can engage the utility in the interconnection process. It takes resources for the utilities to analyze an interconnection. And once it's granted, then there's sort of an obligation to, allow that to be built, for the price of the interconnection cost that's given to the applicant. The pilot program rules don't require us to do anything with that application. We determined, and this was developed with the working group, and ultimately the commission, I think, had comment on that, and our application process was approved. So there's no regulatory obstacle to it. What it allows to happen is if a project has gone through interconnection, it now has access to the capacity on the distribution system at sort of a specific price. And there's obviously other folks that do it.
No, I understand, but
Yes.
I'm trying to, from the utility's perspective, you're going to tell the utility, don't worry that they don't meet the conditions of the regulations now. We want you to put them in the queue.
Again, the regulations, Your Honor, do not prohibit them from going into interconnection. The regulations would prohibit them from being granted capacity in the pilot program, or in this case, in the permanent program.
Right, so why would a utility take that application and say, okay, well, let's go through the interconnection process when you haven't met the conditions for under the regulation. I mean, if I were the utility, I would, I'm not sure
Well-
I'm not sure that this makes sense. I'm not sure that it fixes the problem. And from the utilities perspective, you're putting them in a really sticky situation because they're going to be, I mean, would you tell the utility, take the project, put it in the queue, even though it doesn't meet the conditions of the existing regulations? And we don't know when the new regulations are going to pass. They could be delayed years.
Well, to answer your question, I believe the utilities have commented on this, at least Potomac Edison has, and there was some sort of benefit to not waiting until the 1st of January of 25 to start taking all the interconnection applications. So it may actually help the utilities by spreading out the interconnection work if they allow those larger projects, or any project that would qualify under the permanent program, to begin the interconnection process now. I think the major concern is that there are projects that would not qualify in the pilot program. Anything that would qualify under the pilot program can enter the interconnection queue right now, but they may not be granted capacity such that they could start construction and ultimately be, and energized. So there's the utility has been, and they've agreed to this, when the staff clears a project and authorizes a subscriber organization, we keep a list of these on a
No,
spreadsheet.
but you've done the work. I mean, if you were a utility, and it looks like Mr. Michelle wants to say something.
Sorry. Good morning, Commissioner. I didn't intend to speak, but I want to be clear, at least for the Joint Exelon Utilities, Commissioner Sussman, you accurately represented our position on this, that we don't think those projects should be allowed to enter the interconnection queue before they've cleared the whatever applicable regulations will be in effect.
Okay, and that's the concern I have, is that I'm not sure this is going to fix the problem. I understand what you're proposing, but if the utilities don't think that it's acceptable from their perspective, I think we end up at a loss. So I also wanted to ask you, in your comments, you have a conditional authorization proposal, and I wasn't quite understanding it. So I wonder if you can, or maybe Ms. Garofalo can explain what that is, because it wasn't clear from the comments.
If we have, we're going to go through the process with a subscriber organization that is identical to what we would use for the for a pilot program project. We know exactly by reviewing the law, and we have although we do have draft regulations that sort of are clearly intended to comply with the new limits on community solar projects. We're not going to accept a project conditionally if it's somehow outside of the existing bounds of what's allowed in the law, but we are going to continue with the same process that we use to verify that the subscriber organization is technically and managerially competent and has provided the bonding necessary.
Okay, so I guess the question is your conditional authorization, does that mean that you're going to take co-location off the table? So that if they meet all of the other existing requirements under the regulations, other than co-location, you will conditionally authorize them? And then allow them to go into the queue?
We would effectively, create a document that would allow the utility to see that staff has signed off on the organization and the size of the project. But much in the same way we have an existing process for conditional authorization for projects that require CPCNs. We would say this project, and some of these projects will require CPCN, so that will sort of be standard anyway. But to the extent we have a project that would not qualify to be entered into the pilot program, but would qualify to be entered into the permanent program, they will be authorized to go through the interconnection process and get that interconnection agreement from the utility, such that when the permanent program is becomes active January 1st of 2025, they would be able to make application to the permanent
Okay,
program.
so that, let me just, let me just, I'm going to sort of tell you what I think you're saying. So what you're saying is this is a new concept, conditional authorization, and what it would be is if you meet all the other conditions for a subscriber organization other than co-location, we're going to give you conditional authorization, and that's going to allow you to then go to the utility and get in the queue.
Into
Is that
the interconnection queue, yes.
right? Okay. So, Mr. Michelle, I'm going to ask you to come back up if you're okay with that, and with the chair's indulgence.
Sure, sure, yeah. Is he in the room? Or?
Well, he is. I think he's hiding.
No,
No, I
Oh,
don't.
okay. Oh, I see. Sure, okay. Yeah, yeah. Okay.
I'm sorry, Commissioner.
No, that's fine.
I was trying to get some insights from our SMEs. So let me just have some of our SMEs come up, and maybe they can.
Yeah, no, that's fine, because I'm thinking that what staff is proposing sounds a lot like the sort of another way of thinking about a co-location waiver. So basically, you're just going to say, if you meet all the other conditions, since co-location is no longer a factor anyway in terms of statutory language, that we're going to take that piece off the table, and we're going to give you something called a conditional waiver. So it's a new concept, and it'll be sort of a transition concept because it's only going to be in effect for some months until the new the new regulations go into effect. And I guess the question is that something that the utilities would recognize as qualifying for the interconnection queue?
Yeah, so I'll start by simply saying the Joint Exelon utilities, our primary concern is that when a project gets the green light to enter the interconnection queue, that project should be considered finalized and ready to go. And the reason why we have that concern is that as Mr. Vanderhayden specified, it takes a lot of resources and work for our team to assess, do the engineering studies for projects in the interconnection queue. And if we get an influx of projects who are conditionally approved, and for whatever reason later on we realize that, this project shouldn't have been approved or it needs to be changed for whatever reason, then that work is wasted and we have to start that over.
No, I appreciate that. So, yeah, and that's, yeah, conditional, the word conditional is a loaded term.
Yeah.
And I can understand from the utility. So, but if you were to get a project that has the co-location provision waived, so that they have a subscriber number, and they've met all the other conditions, that's a project that you don't have an issue with.
We do not have an issue with that.
Okay.
But Commissioner Sussman, just so I guess the record
yeah,
is clear,
please.
I would ask, what then does it mean for the project to be conditionally approved? Because that term suggests to us that there could be changes to the project.
Yeah, and I understand that for all lawyers never like to hear conditional unless we want the conditional word in, right? Because we don't really know what that means, and I understand. But I was mostly just trying to understand what staff was proposing. So I guess the question is, from staff's perspective, because conditional authorization is a new term of art, and that always, for lawyers, that always makes us really nervous because we don't really know what that means. If instead we were just to be clearer and then just to waive for this applicant, we were to waive the co-location requirement, what would your position, staff's position, be on that?
I would say that folks have asked for a blanket waiver for all projects. I think if you waive just one project, then you're advantaging that project potentially against other projects that would also want to interconnect.
Well, they can always come to us and ask for the same thing. We're not, if we gave them a waiver, we wouldn't say only they get a waiver and nobody else. So
the the regulations, there's, like, if you waive the regulation, I think you're saying you can co-locate, I don't know how we would write that waiver. I think what we're proposing would allow us to use the existing regulations and the law to sort of craft very specifically what can enter interconnection. I'm hearing that maybe the utility folks want the entire, they want it waived permanently, although, you know, even there is
I think from their perspective, it's the conditional language, because then they would have to expend money and time, not knowing whether you know, whether the conditional language is going to put them at risk.
If I may, I don't think there's if a project is going to change, it could certainly change even if it's been waived. And if a project were to be changed, our application process requires that to go back through and have that amended. So I don't know that it's primarily a concern. If there's a desire to waive 2062-0308 as what has been requested, it's not clear to me what the actual effect of that is. It seems more directly clear to me that if staff is going to allow projects to go through the interconnection process, that's it. Like, it's very limited in terms of.
Well,
what
so
can
I'm
actually
so
happen.
I'm asking you for this particular project. So this is the project that's before you. What would be the impact if we were to allow the co-location condition to be waived?
I think you would allow the project to proceed to construction as if it had been accepted into the pilot program.
Okay, but do you have concerns about this particular project if we were to approve the waiver?
This particular project, I don't know that I can tell you specifically if I think that individual location is a problem for this, or if there are other projects that would be harmed by that. So I don't know that I can give you an answer to that. I think we were looking at it as if there's a desire to sort of get the process started early, this would be a way to achieve that. If you waive the regulation entirely, that might be actually letting these particular processes.
Just the co-location provision, not the whole regulation, just co-location.
So the co-location provision would essentially allow more than one project to be sited in excess of, I believe, 5 megawatts.
Right. And so so my question to you is, what concerns do you have for this particular project?
So-
If we were to approve the waiver for the co-location restrictions.
To the extent that I haven't studied the location of the particular project to tell you whether or not adding, and I think they're looking at adding, I'm not sure what the total number of megawatts. I think it was a multiple, like maybe twice as what has actually been accepted thus far.
Okay. And then you're also concerned that the impact this would have in terms of other projects?
Well, I guess every other project that would see this is, oh, we got to get our application in to get a waiver for this for our project.
Okay, and that's your concern as well.
That's a potential concern. I don't know how many there are. It would just be a matter of processing all of those, which may take some period of time. I really hope that the regulations for the permanent program will have sort of been adopted by sometime, late summer at the worst. So it may take that long to go through any number of.
So this is really, I mean, in terms of the actions that we're taking today, this is really just a 3 or 4 month period of waivers, if to the extent that there would be waivers, because presumably by the middle of the summer we'll have new regulations and this won't be an issue. So this is just a temporary fix, little Band-Aid for issues. So we're not talking about multitudes of projects coming in trying to get a waiver.
Hard to say. If there are projects that are contending for a particular spot on the distribution system, they may feel it is a need to get that application to the commission, and if if the projects, if it's already sort of in planning phase, they may have to accelerate that. We really can't see what's going on outside of the applications that come to us, so it's sort of hard to tell. But to the extent that a specific project was waived and allowed to go forward, that I mean, I'll let Ms. Garofalo sort of address the legal issues associated with the ruling that was recently made, in this case, regarding that. But I think our concerns are, do we have a process that's fair to everyone, not just the current applicants, but any applicants that presumably would be planning to apply for project space, either on the distribution feeder itself or actually within the 3,000 megawatt cap, such that if there's an advantage to those sort of incumbent folks that are already, in the game now, would there be disadvantage to smaller or sort of later arrivals?
Well, I mean, the fact of the matter is the legislature changed the limits, and so I guess you could say that was unfair to the people who were subject to the co-location restrictions until the legislature changed them. But I guess and I guess Ms. Garofalo, I'll put you on the spot. So if we were to allow for a waiver for the co-location issue, can you identify for us what you think the legal impediments to that kind of waiver would be?
Well, you could grant a waiver under the temporary program, the non-permanent program, and you could grant for one, or I don't know that it's ever been done, but I guess you could grant a waiver for the total, all who want to apply for such things. I think we don't know what would happen with that, so I would recommend, I personally, if I were in your shoes, would be hesitant. But I think that I'm not sure you could do one under the permanent program because we don't have the regulations.
Right. But we could grant a waiver for this project, but not put any restrictions on anybody else coming to us, and then it could just be on a case-by-case basis.
You could, and I think I said before when we dealt with this at the administrative meeting that, and as Mr. Vanderhayden said, we don't know how many of those there are, but it might be a sizable number.
Right. But it would be until the new regulations were to go into effect.
Yes, and I think the time frame we're looking at, I think the minimum is 6 months by the time you send the things to Annapolis and they come back, and you have your other meeting.
Right. Okay.
Commissioner Barbie.
Okay, I think my first question might have been answered, but let me just, so it's going to be 6 months to finalize the regulations?
I believe it is. I didn't do it for this meeting, but I have done it in the past, and it turned out to be 180 days.
Okay.
If everything went swimmingly.
Right,
which
and
I'm sure this will.
And at that point, then, all those projects would go through all of the entire process, which they would start at that point, going through the process. Right?
They would be able to, there would be new regulations in effect. When they file their application, which I guess we could be working on during the period of the regulations, then that.
But that's when the clock. That's when the clock would start.
The clock would begin to run, and then they would go to be approved and sent to the utility.
Okay, so maybe I'm looking at this too simplistically, but it appears to me that the most effective way to comply with the intent of the legislature would be to grant a blanket waiver for all of these co-location issues, because it's clear, I mean, it's clear to me at least, that the legislature intended to get rid of this as an impediment. So why wouldn't just a blanket waiver based upon co-location, why would that not be the most straightforward and efficient way to comply with the legislature's mandate?
Well, I think the General Assembly was rather wise in the way it worded it by allowing for, first we need new regs that would deal with this legislation we're passing. And so
But
I would say that would be the reason I would rely on.
Well, I've seen us screw things up before in the legislature, but it appears to me that of all the complexities associated with building solar generation, co-location would be possibly the simplest.
The bottleneck is the interconnection process.
Okay.
All you need to do is find a way to allow projects that would be accepted at the larger sizes and co-located into the interconnection queue. Our current rules do not address the interconnection queue at all. If you waive those rules, it almost is as if you are allowing projects that can't be built in the pilot program to be built in the pilot program, because then that project would then have to follow the pilot rules. And it's not clear that those projects would still have the 40% LMI requirement under the permanent program, because those regs aren't in effect yet. It's not clear if they would be, pushing out capacity in other categories. So I think everybody understands that the problem is these are large projects. They want to get the interconnection process started, and we need to develop a way that sort of cleanly allows that to happen. I think waiving the entire co-location regulation may open up more cans of worms by assuming that's the only thing.
Well, how? I mean, the legislature's ruled on this.
They have ruled on a series of instructions as how to set up the permanent program. But like, if you waive the co-location rule, it's not clear that what you're doing is moving those into the permanent program. You're just allowing those larger projects in under the pilot.
Okay, I'm still confused.
Okay. Commissioner Richard, and then I'll go back to you.
Yeah, I guess I'd like to move on actually, so we can hear from the industry. But I guess I'm trying to. We have at least 6 months, if not longer, that if we wait for regulations, that we are going to be holding up projects, large projects that we need on a timely basis. And so I think that's what we're trying to get to today. How do we make sure that this commission is not an obstacle to getting these projects moving? A lot has happened, since we did these original regulations. The state mandates, the goals have changed, yet I don't feel like we're keeping up. So I think that's what we're trying to do today, and we're trying to understand staff, at least I'm trying to understand staff concerns. If we have a waiver process, and we do a blanket, aren't we facilitating, helping staff to move through at least certain aspects of the SO process so that we can get these projects into the interconnection consideration process? I mean, your staff is still going to have an opportunity to review these applications. They just can check the box on the co-location issues. So help me understand what the concern of staff is.
I think everyone agrees that we want to provide an opportunity for the large projects to reach interconnection.
It's not we want to. The legislature, as Commissioner Barvey has said, has told us to. That this is the new requirement. So we know there is not a co-location issue that's been taken care of. You mentioned the 40% requirement. That's in law now. So it's quite clear what the requirement is. I don't understand why staff thinks that this is something we need to hold up good projects.
I don't think we're trying to say that at all. I think we're just talking about, we believe that the method to do so would simply be to direct staff and the utilities to allow these large projects to go into interconnection. The regulations don't address the interconnection queue at all. They address whether or not projects can be accepted and be treated as if they are.
Okay, I feel like we're just going in circles here, but we
Yeah, I'm
this
sorry.
process,
I'm
the
sorry.
process is basically
Yeah.
preventing these projects to be considered by the utilities to go into the interconnection.
Right. There's nothing that prevents that from happening right now. Like, there's no regulation at all that says you may not accept an interconnection request from any project.
I feel like we're just going in circles here. I mean, obviously, we've heard the utility, it wouldn't be prudent for them to take these projects unless they've gone through the process that we have in place. So I'm
trying to be
I think
responsive.
We're just trying to figure out, how do we get things moving until such time as we have promulgated regulations that have gone into
So I think if you, to answer the waiver question, if you waive this section that allows projects that prohibits co-location, you're waiving that for the pilot program. And so in other words, the regulations, like the regulations that are in front of you don't have that prohibition in it, but there's no way to waive that if it's not, that doesn't need to be waived. What the commission just ordered that we should follow the existing pilot regulations until such time as the new regulations are in effect. But
Okay,
I'm sorry if I'm not-
I've heard, and we've got some recommendations in front of us. The only other thing I wanted to find out is you were talking about the various work groups. There seems like some really common sense, recommendations that we need to have addressed in the work group process. Are you saying that we don't have the work groups in place now to take these recommendations, or
No, we do.
Do we think we need a new?
We do. I think what we're suggesting is that many of the suggestions you have in front of you are in fact interrelated. I think what we're saying is it would not be helpful for us to split those into multiple, different work groups to, focusing on isolated issues, because they're all involved, and our resources would be better spent on a combined working group the way we're doing it now.
Okay.
I'm sorry if I'm not.
Do you think that, I think there are 4 or 5 recommendations. Yeah, 4 recommendations. So do you think the current work group process could handle those 4 recommendations and do it expeditiously?
I believe so.
Okay, great. Thank you. Thank you, Mr. Chair.
So let me ask a couple questions related to the regulations. So what I heard was best case scenario, 6 months to get these things in place, given what we have to do. Were the regulations drafted as the result of a work group or just staff on its own?
They were drafted as a result of the work group.
So my next question is, and this requires a little guessing on your part, are these regulations going to be subject to a lot of suggestions by other parties about changes, or do you think that, most of the discussion points in the regulations have been resolved by the working group?
We have endeavored as much as possible to deliver you a product that you can see what the alternatives are, who proposed them. So the majority of the language is changes that simply comply with the law, and those are for the absolute most part consensus. There are areas where folks have added some things that they would like to see either as improvements, but aren't necessarily part of a compliance regulation for the law. Those have been sort of boxed out into alternative language or highlighted in different colors indicating who's proposing it. So with proper, and we're going to attempt to tee everything up for you at the hearing so that you can kind of see this is what is consensus, this is what is not, and then parties will need to file their comments to sort of advocate for one or the other. Once you have a hearing on this, if you adopt, like in a single hearing perhaps, I think that's entirely possible given the way it's sort of laid out, and it's very specific. One of the bottlenecks is sort of doing the documentation for Annapolis, doing the fiscal impacts. I anticipate that we are going to try to accelerate that process by drawing upon our experience doing that. And there's some hope that we can very quickly, send those rules to Annapolis, have them, that's up to them. They, how long they take is their schedule. But I think we're going to try to facilitate that by doing a great job of documenting all the financial impacts. With the expectation it comes back to the commission, as soon as possible for a final hearing, which at that point, there shouldn't be much in terms of changes. Much of what's being proposed is simply, compliance with the law.
All right, what about, so I guess the other thing I'm concerned about is during this time period where we're considering the regulations and going through the process of getting them promulgated, if we're doing a whole series of sort of one-offs because of this waiver process, because I'm assuming that the community solar folks are not going to wait until the regulations are adopted to push projects. They're going to start doing this starting tomorrow. So is there a problem if we're approving a number of waivers of projects before we have the regulations in place, that we have like differing standards for various projects?
So the law really lays out like what can be co-loaded, what can't, how big everything's supposed to be. So I think if we follow that in terms of looking at waivers, saying, well, this wouldn't fit in the pilot program, but this is a project that would clearly fit under the way the law is written out. That should get most of it. There may be there's a couple things that are sort of unaddressed that maybe need to be thought about. That if you were processing those individually, doing individual waivers, it wouldn't be necessarily fast, depending on the process that's used, if it's the administrative process. But presumably those wouldn't be very difficult to figure out, and maybe could be done in sort of some faster process. Seems like individual waivers would sort of take longer than the approach you're suggesting with a sort of a blanket. But it sounds like if there's a sort of a waiver of that section, and that means that the utilities say, okay, you waived this, we'll accept these into the interconnection queue. If it's very clear as part of the way that waiver is written up, that says this simply means you can go to interconnection, and it does not mean that you have to follow the pilot conditions. You will file whatever conditions are in effect once those new rules are in effect. Sort of like how that waiver is written out. I think it's the same effect as what staff was thinking about, without going through a waiver process. I think maybe that's the way to sort of thinking through this, how that would work. And in which case, I think like doing it at one shot with some sort of announcement to all of the parties, as best we can, that we're about to do this. So, if you have a desire to move a larger project, here's how you're going to be able to get the interconnection process started for it, under the conditions of the commission's waiver.
Okay, so let me turn to the applicants, and obviously state whatever your concerns are, but I would like you to address two issues. One, I'm assuming that you're not going to be willing to wait until the regulations are in place to start bringing projects forward. And then the second issue would be, you've seen these draft regulations. I mean, is it probable or possible that your applications for waivers will closely follow the proposed regs, even though you don't necessarily have to follow those regs? So
Sure. I'll address your questions. We would like Mr. Wallace to go first on behalf of Turning Point, then I'll give our comments.
Because I don't want to lose this.
Okay.
So this last.
Oh, yeah.
I'm sorry. I'm just talking to myself. So the last exchange you just had with the chair, you said that conditions could be put into the waiver so that when it goes to the queue, the condition is to follow the regulations as they exist now, and then will be when the new regulations come into effect, those regulations would apply to what's ever in the waiver. Is that what you were?
Yeah, I'm sort of anticipating that it should be very clear that someone who applies under this waiver understands that they're building a project for the permanent program with those conditions. Now, the law lays those out very well.
Okay, so is this an approach that staff could accept?
Yeah, I think if the way the waiver is written sort of clears up any sort of misunderstandings about what's being waived, and by being very distinct, it has the benefit of making BG&E happy that they have a clear waiver of something from the commission, and I think it would make us happy if it's very specific in what is being allowed and what is not.
Okay, so Mr. Wallace, when you make your presentation, I would love you to be able to comment on that, because maybe we actually have a path forward. I'm very optimistic about lots of things. So this is my optimism coming into play.
I want to be clear, Commissioner. CCSA is going to cover the market waiver concept, and then Turning Point's going to talk about their specific project. So kind of split it up in that way. But we'll address your questions.
That works.
So I think to begin, and I'm going to touch on those specific questions. I think those are important points to sort of resolve this and put this whole issue to bed. But I think, given where the discussion has gone this morning, I'm not going to, just stick with my prepared remarks. We covered a lot of ground already. But I think what's important for the record is to look at how we got here. And this process started in May of 2023 with Turning Point applying to staff and the commission for the SO approval for this group of co-located brownfield projects. And, as was discussed in the previous pleadings and at the hearing on January 10th, staff identified the existing pilot program co-location rule capping the aggregated capacity at 6 megawatts as the regulatory barrier that was preventing staff from approving these projects so that they could begin the interconnection process so that these projects can ultimately reach commercial operation in 2027, right? So we're not talking about, a waiver granted today is not going to result in co-located brownfield projects, reaching commercial operation before the regulations that staff filed on Monday take effect, right? It's not possible to do that. We had a commercial operation deadline extension on today's admin showing, consistently they take 2, 3, or more years for these projects to move forward. These haven't even started the interconnection process. So, as a practical matter, whether you put conditions on the waiver or not, projects that are going to be utilizing this waiver will not reach commercial operation before these rules go into effect. But I think what I really want to stress is that we are asking for a waiver of the co-location regulation. That was the issue that staff identified as the barrier from allowing these projects to move forward. What they proposed in their comments and talked about today sounds a lot like what Turning Point asked for in its previous filing, and the commission rejected, finding that the rejection was based on COMAR 2062-0308B3, which is the 6 megawatt, cap. So we are asking for a waiver with respect to these particular projects, or a market waiver. Turning Point is open to either solution. And to the extent that the commission is concerned about, additional projects coming forward to seek similar situated brownfield projects seeking waivers, the market waiver certainly is a common sense solution to address that issue. I think it's important to keep in mind this is a brownfield site that is, where Turning Point is applying for 4 different projects that are going to be co-located as part of a broader redevelopment of the whole site into residential, commercial, green space, and solar. I mean, this is the exact kind of project that the General Assembly had in mind, and was dreaming about when they passed HB 908. And now we've identified a discrete regulation for the legacy pilot program regulations that's getting in the way of progress. And so I think, it's hard to imagine a better case for good cause for waiver of a regulation than this scenario. And so wherever the discussion goes today on broader reforms to different aspects of the program, I think we don't want to lose sight of this discrete issue that has been a barrier for these projects since they applied in May of last year. It's been almost a year that these projects have not been able to get into the interconnection queue, start to get studied by the utilities, and begin that multi-year path forward to be part of this new kind of development that's sort of a jewel of what can be done with community solar as part of brownfield real development in Maryland. So I think that's the critical piece that we want to highlight. And given the history, in the prior proceeding, and the identification of that regulation as the barrier, we think that a waiver is necessary and appropriate to give the utilities the certainty that they need when the projects come in for interconnection, and to give staff the direction they need to go back and approve the projects that were applied for back in May, that have been stuck in this regulatory limbo here while we've been working to find a path forward. So that is the critical piece. With respect to the 2 discrete questions that Commissioner Suchman had, the regulations that staff filed on Monday, if it's a 6-month process, I mean, we're talking about these projects moving into interconnection, just beginning the study process, you know, and so the bottom line is that there's no reason to make these projects wait. I think Potomac Edison made a good point in its comments, which is if you allow these projects to start moving forward, it helps to prevent a situation where there's a bottleneck on day one that those new regulations go into effect. Let's prevent that bottleneck by providing a path to start the process, understanding that these projects are not going to reach commercial operation before those regs go into effect. And to the extent the commission, is inclined to put some clarifying language in its motion, if you're inclined to vote on a waiver today, which we certainly hope that you are, that's our request at this hearing. We'd like to walk out of the hearing today with a vote on that issue. That's fine. But from a practical matter, it's not possible anyways. And then with respect to the draft regulations, the HB 908 is clear that it's removing a cap on co-located brownfield projects. So, these projects will be able to comply with those new regulations when they hit the books. However, the commission may tweak them during the rulemaking from what staff proposed. That piece isn't going to change because that is a clear legislative directive in HB 908 that's being reflected in the regulations. And so there's just, we don't see any concern or potential risk there that there would be some kind of conflict if you grant the waiver today. I will pause there and turn it over to Mr. Bugelmans to give CCSA's position. We're happy to discuss the other issues that were brought up in the comments that we addressed in our written comments pretty thoroughly. So if the commissioners have any questions, we're happy to address those. But our core focus today is making sure that we get an answer on the co-location issue so that we can start that interconnection process.
So before we turn to Mr. Bugelman, is there any questions about the specific waiver request that's before us? Okay, so go ahead, David.
Thank you, Chair Hoover, Commissioners. Again, David Bugelmans on behalf of the Coalition for Community Solar Access. We would like to thank the Commission for taking up this very important topic, both this waiver issue, but also the SO process. As we indicated in our written comments, the SO approval process is the most important first step for the development of any community solar project in Maryland. Without SO approval, even though, as Mr. Vanderhaden said, this is not written in regulations anywhere, the utilities won't allow projects to apply for interconnection until the SO application is approved. That is an absolute fact across all the utilities. It's something developers work with every day. So figuring this out is very important because without being able to move forward with SO approval, you can't move forward with interconnection. In CCSA's comments, we addressed the market waiver, which I'll talk about in a second, but we also have 4 longer-term topics that we think deserve further consideration through a work group. And we think that by granting a market waiver today, coupled with taking a closer look at these other topics, we'll be able to address sort of this immediate near-term need with the transition to a permanent program and then also improve the process moving forward at a deeper level. With respect to CCSA's request for a market waiver, CCSA's specific recommendation is for the Commission to grant a market waiver of the co-location requirements detailed in COMAR 2062-0308A and B for co-located community solar projects that meet 2 conditions. And I think this goes to Commissioner Sushman's questions about how could you condition a market waiver to make sure that there's appropriate parameters. So the 2 things that we've recommended is that the Commission would grant the market waiver for projects that satisfy 2 things. First, they would need to satisfy the permanent program co-location requirements. Again, the law passed by the General Assembly has the co-location requirements in statute. It doesn't give the Commission discretion to change them. It just says, here they are. And then it says, as part of the first rulemaking, basically change your regs to conform with these requirements. So we know what they are. It's something the Commission could easily point to, and that is a defined thing that would give a standard to review these SO applications against. So it's not completely open-ended. The second thing is that these projects would need to be constructed under the permanent program and subject to any requirements of the permanent program. So to the extent that there's specific requirements for those projects adopted through the rulemaking, again, co-location we already know, but anything else, these would be permanent program projects. Again, the idea here is just to allow these projects to move forward with respect to interconnection. Mr. Wallace already covered this, but we also agree with the point he made about the need for a waiver here. When I was before this commission on this issue last time, our position was that a waiver wasn't needed, that the staff should basically approve the SO application for these projects because they're going to be permanent program projects. And staff's response to that was, we can't do that because it's inconsistent with the regulations. And then now we're here today, and staff is in some ways asking for the commission to do what it said it couldn't do last time. So, the commission said in its order in this case that the regulations would need to be waived, and for that basis, we think it's important both for projects and along the lines of some of the previous discussions this morning to provide the utilities with certainty that this is okay from a legal perspective to apply for interconnection. So we think that's consistent with the commission's order and the direction that the commission went the last time the commission considered this issue. So real briefly, just to make sure it's on the record, the 4 independent justifications for good cause shown to build the record on that point are as follows. The first is the need to ensure smooth transition from a pilot to a permanent program. Again, these projects can't move forward with interconnection unless our applications are approved. So it's really important to grant the waiver to allow these projects to move forward. There's been some discussion this morning along the lines of how does this fit into the current rulemaking process, or we're just talking about 6 months. I will say a couple points on that. There are many developers waiting for this, and they've frankly been patiently waiting for the Turning Point request and for this hearing today. Even the Turning Point request itself, you have to remember that took many, many months to work its way up to the commission, because that had to go through the SO process. We had to file the waiver, then to get on an admin agenda, it takes 3 months. So time is running out, frankly. And my concern would be if the commission were to grant only a narrow waiver for Turning Point, which again, we don't oppose if the commission were to do that by any means, but then we would be in a situation where there's just such little time left. The idea of having to come in, and file individual requests and make it to admins after 2 or 3 months, we're just kind of losing the benefit that we're trying to gain from this. So again, that is, I think, the primary justification for a market waiver here. A couple other points. Second, good cause. The General Assembly has specified in statute that it prefers projects and wants to incentivize projects on environmentally beneficial sites like brownfields, rooftops, carports. It's been a discussion this year with policymakers in Annapolis. By granting this waiver, you would allow these projects to move forward in the immediate term as opposed to simply waiting until the permanent regs are in effect. So that is another good cause justification. A market waiver also, as a third reason, would address equity concerns in a number of ways. First off, it would treat all developers uniformly. So any project that conforms with HB 908 would be able to move forward with SO approval and interconnection as opposed to doing it piecemeal for 6 months. It would also, in our mind, conserve commission and staff resources by avoiding a case-by-case waiver. These take time. They're obviously not the most difficult things the commission does, but you have to deal with a couple of these at every admin meeting potentially, so that does take time. And we also see this as eliminating a backlog of applications, because if you weren't to grant a market waiver, what would happen is all these projects would apply right when the permanent program starts. So if we do this now, again, recognizing staff is already getting these applications, really the difference would be instead of denying them, they would be approved. It would sort of spread them out over these 6 months as opposed to doing them all at once. And then finally, there's also just a general policy benefit in terms of meeting the RPS, the 14.5% requirement in the immediate term to deal with the SREC undersupply issue. So we view those as all 4 of those reasons as good cause to grant a market waiver. And we urge the commission, as Mr. Wallace said, to reach a decision on that point this morning if possible. I know I've said a lot. We've been here at this hearing for a while this morning. We do have 4 other long lead time topics that we'd be happy to discuss with you, but I'll skip those for now. Mr. Kokoshaw, do you want to?
Sure. Thank you, David. Mr. Bugelmans. I'll be brief here. Thank you, Chair Hoover and Commissioners. You all have covered a lot of important ground this morning and have raised some excellent questions and are clearly well informed. So I'm not going to go through my whole script. I'm just going to emphasize some of the points that Mr. Wallace and Mr. Bugelmans made, and also trying to address some of the questions that you all raised. One is that the development is indeed happening now with an eye towards the permanent program. Development is not just kind of stalled. These are, real kind of conversations, deals, business movement that's happening, investment that's happening in Maryland. This is not just a Turning Point interest to seek co-location. There's other developers that are seeking that as well and interested in that as well. And as Mr. Bugelmans mentioned, there was a kind of a wait and see to kind of get the precedent of the Turning Point application first. But it would be much more efficient to do this market waiver because, as Mr. Bugelmans noted, the clock is kind of ticking now. And the further down the year we go, the more it just doesn't really make sense. I also just want to emphasize how timing is such a critical element of community solar projects. There's a number of different things that go into it, and as we heard earlier in the administrative meeting, permitting, interconnection, there's all these different layers to it. The SO process is one of those layers, and we don't hold kind of the commission responsible for all of the reasons for how the timing works out or doesn't work out for a community solar project. And we're only kind of pushing you all on the areas that you do have some discretion and control over, which is that SO approval process. And I think that kind of wraps up the primary points I wanted to emphasize, other than just kind of circling back on the waiver aspect, which, as Mr. Wallace captured nicely, these are for preferred siting projects on brownfields, on rooftops. These are kind of the reason that there's co-location eligibility for those types of projects is to incent that type of development to happen. If we don't kind of allow those projects to move forward with interconnection now, that means they might not be seeking interconnection applications until next year, a year from now. And that itself is another test, kind of viability test. So there's no guarantee that those projects will work. The sooner we can kind of get them into those processes from a development standpoint, the sooner we'll kind of let them flesh out and hopefully, reach development and operation in the next few years. Thank you.
So, any questions for the applicants? Commissioner Richard?
Thank you for the presentation. Just so I understand then, so for the market waiver concept, your proposal is focused solely on the co-located projects on preferred sites. Is that correct?
It's for anything that satisfies the new requirements under HB 908 that passed last year. So I called them preferred sites, but it's everything in the statute. So it's basically if a project satisfies what is now in the law, that would be approved if the market waiver was granted, or it would allow them to move forward, and receive SO approval effectively.
I was just because I was also just comparing that with I think how I was interpreting OPC, and they were talking about a waiver for anything that conflicts with HB 908. So you actually are perfectly aligned then with what OPC is.
Yeah, I think we would generally support that. I mean, we this is narrow. We're focused on co-location. Really, the reason is the statute is prescriptive on this point. A lot of the other points in what was passed require regulations to kind of flesh things out. But this is one area where we know what these requirements are, so we focused on that.
Okay. One of the areas that I think even staff brought up this morning was the LMI requirement of 40%. So is that something that we would have to potentially go back to if we don't specify that now, or do you think that's clear in statute that it's not anything that would have to have some kind of a waiver as far as?
So again, our recommendation would be for the commission to grant a market waiver. One of the conditions would be on compliance with the permanent program requirements. One of those requirements is the 40% LMI requirement. If the commission wanted to specifically call that out, I think that would be appropriate to make that clear. But the assumption is, these are permanent program projects. We're not trying to get these in under the pilot, and they would be subject to those rules.
Oh, okay.
And Commissioner Richard, if I may just add one point, which is, from a sequencing standpoint, the LMI requirement is a requirement before you begin commercial operation, which isn't going to be happening for, multiple years from now. So you could grant the waiver now, allowing us to start the interconnection study process and without addressing the LMI requirement, because it's not projects don't go out and secure LMI subscribers before they begin interconnection. They do that way downstream when they're, they have a clear timeline for when they're going to start. Then they go out and they enroll customers, and they have to achieve that requirement when they hit commercial operation.
Okay, I just was asking to make sure that we're not back here in another few weeks because we have another impediment. So, because I think it's either 40% or the project is owned by the subscribers themselves. I think those are the two.
That's correct.
So there's nothing there that we need to address today. It's simply the co-location issue.
Again, I think in my mind, if this was conditioned on complying with permanent program requirements, that would cover the 40%. But if the commission were to want to call that out, I think that would be appropriate too.
Okay. And then as far as the other recommendation of the CCSA on the work group items, the 4 recommendations, is that something that we would need to put in an order, or just express that please, as expeditiously as possible, address these 4 items? Or do you have real concerns about the current work group process?
Yeah, I mean, here's our concern. So the net metering work group has been very productive with the adoption or the development of the regulations we're going to consider soon for the permanent program. But looking ahead, there's a lot of complicated things that group's going to have to figure out, such as consolidated billing for the community solar program. And my concern would be just making sure that these issues are not lost in the mix. So if the commission were to keep it with that work group, which is, that's obviously a question for the commission and staff, I think some guardrails in terms of these are the topics we want considered, and this is the date where we want some kind of report, maybe that's in several months. I think some guidance would be useful. But that's really the main concern is we're going to have to deal with a lot in that work group. These are very important issues, but they're also not something that the commission has to consider under the law, right? So we just want to make sure they don't get lost.
Okay, I definitely have heard you on that point.
And Commissioner Richard, one additional thought there. I mean, I think one concern that Turning Point had is, there are lots of different things going on, and including staff just filed the proposed regulations. And so what we were, in our comments, our proposal was that there be a separate track for this subset of issues that would, that wouldn't conflict with the rulemaking, because we have a deadline to get the HB 908 regulations on the books by the end of the year. And I think it's important that move forward, and a work group could look at these broader kind of, programmatic changes that aren't specifically implementing the statute in a separate track that to prevent things getting bogged down and mixed together.
Okay, great, thanks. And so just to be clear, Turning Point is basically asking for the same thing that the market waiver would be asking. So there's really there would be no difference. It would just, one would be specific to Turning Point's project. The market waiver would be to all projects that qualify under HB 908.
That's correct.
Correct.
Okay. Terrific. Thank you. Thank you, Mr. Chair.
Mr. Barbe.
Going good.
Mr. Sussman.
Okay, so Mr. Bugelsman, I have a process question. So for the blanket waiver, and it would be conditional on meeting the 2 provisions in the statute. So it's not, we wouldn't be giving a waiver to the co-location requirement. There would have to be a determination made.
Right, there would still be determination by staff.
That's my question. So staff could approve or not approve the waiver.
Just to be clear, the commission, what we have requested is for the commission to waive the pilot program co-location regulations, and effectively in place of that make these the new requirements. Like if a project meets the requirements under HB 908, staff, when it receives an SO application, would review a project, as it does now under the pilot regs, would review a project, does it meet one of these exemptions? And if it does, then it could be granted. So it would fit into the SO process, effectively giving authority to the staff to approve these.
Right, and staff would look at the provisions in the statute and make a determination, And if they said that it didn't meet the conditions, then that entity could come to us, like Turning Point did. And so I guess, Ms. Garofalo, does that kind of sort of address some of your concerns about doing a blanket waiver by requiring each applicant to come in and to get a waiver from staff based on certain parameters?
Yes, thank you also for asking me a question, because I have 2 points I want to make.
But you have to answer my question first, and then you can make
in
your
answer to your
points.
question, I think that we would be happy with that, and the reason is that we currently get applications which would be appropriate for the permanent program like TPE, but the bulk of our applications are still ones that would be appropriate for the pilot program, and so that we would need to look at at that, and what you are proposing would give us that ability to make that
And
decision.
Mr. Bugelmans, that's something that your association can live with if that's the process.
We continue to support staff reviewing SO applications, and that would include compliance with requirements. I want to be clear, what we're saying is that with respect to co-location, staff would review for compliance with the new co-location requirements. So if a project meets them, that should not be an issue. If there's obviously some other issue with the SO application, staff could deny it. But if the requirements for an exemption for the co-location restrictions are met, for instance, if it's on a brownfield, our position is staff would need to approve it. So it is a waiver, but we're not suggesting that this should be discretionary.
It's a waiver that they will make the initial determination on.
Exactly, for compliance with these requirements.
Okay.
Yeah, I think that perhaps while Mr. Bugelman's clients may all want to apply for the permanent program, that we do hear from a number of people who want to apply for the pilot program. It may have to do with the LMI requirement difference. I don't know. I don't pretend to know the reason, but we do get that differentiation.
Right, and it gives you the
application.
ability to manage the proposals coming in
Correct.
and to balance the different issues in play.
Correct.
Okay.
Correct. The main thing I wanted to say, we've had, I think, at least one person, maybe two, suggest that you rule from the bench, and I would appreciate if you rule from the bench, if you would say that part of your ruling would follow in an order. And the reason for that is that there's a lot of detail that's been discussed today. There's a lot of detail in the regs and in the new statute versus the old statute, and we want to be sure that we understand your ruling completely. That's all I wanted to say.
That's actually all the questions I
Okay.
had.
So, one question I have, there was this suggestion about handling this in the current work group, and then a sort of qualifier on that about what's going on in that work group. So I guess what I need to know is the issues that are being raised in this situation, are they going to get stuck behind other stuff that work group is already working on?
I think many of the issues are interrelated, and I think one of the best ways to sort of keep things on track is to, we've scoped out what needs to be done as a result of the changes in the law. These are changes that I think will involve some aspects of it. For example, if there's a suggestion that the commission should revisit bonding issues, once we do consolidated billing, and you see at some point, the utility purchases the subscription, there's the same issues that you run into with supplier consolidated billing for retail choice. Bonding is going to be something we need to sort of consider with all these. Many of these issues, if not all of them, are completely interrelated, and the concept of sort of separate tracks to me could involve us, sort of being diluted a little bit. I think we've heard these issues identified. I think the working group is fully capable of sort of putting on like we can print out here's what we're working on, and folks have concerns that things are falling off, we can go back to that, to some form of a document to keep track of all those things. I think it's just, staff is just saying, our preference is to keep it all together and not, have multiple tracks to try to just sort of manage things in isolation. I think there's clearly some benefits to getting those done faster, but we have a lot of resources to allocate, as do many of the, the participants. The net metering working group has a huge number of folks that follow it, and many of those issues are common, and so I think it's better to keep it all together, and I don't think, managing those issues and keeping them on track and not letting things drop, I don't think that's a problem, given, especially is where we are now in terms of development.
Okay.
Yeah, I just add, Chair Hoover, that we're totally good with using the existing stakeholder group that Phil runs to address those issues that we outlined in our comments with CCSA. It's mostly that we're calling it out as a separate work group, in part because the consolidated billing kind of aspect of the regulations is on a longer timeline. And so the rules for that get adopted July 2025. It doesn't have to be implemented until 2026. But some of the aspects, potentially all of them, relate to kind of the application process at the SO, which we would want to have, effective for, early 2025 on a different timeline. So ideally, I think some of these issues, I agree with Mr. Vandenhaven that there's some overlap and things are kind of connected in different ways. But ideally, we get these kind of application elements addressed in the near term, the next month or two. Consolidated billing is really kind of a big complex item that we don't want to push into that timeline as well, because we need all the time we can get to implement it and get the rules established for it. So we're mostly just sensitive about the timing there, and I just want to call that out. And I think Mr. Bugelman's mentioned it would probably be helpful to have like a deadline or some sort of reporting back to you all to check in on it, to make sure that we're kind of staying on pace.
Okay.
Just briefly, Julie Bell from the Office of People's Counsel. Commissioner Richard had raised the question of whether there was any daylight between what Mr. Bugelmans is proposing with the market waiver and what our comments some time ago recommended with respect to the Commission issuing an order finding a good cause presumption for any application that met the non-discretionary changes under HB 908 under the pilot program. So if it met the requirements of HB 908, the process would allow for the finding of a good cause waiver. I don't think there is much daylight between what our recommendation was and what he's recommending, but what we were trying to do with our proposal was give staff the ability to review those applications and object to any that it thought were not in compliance. And I think that sounds like what the parties have been describing today. We have no objection to staff attorney's request for an order, though, that makes clear what the Commission's findings were today if it does rule from the bench. And I have nothing further to add to that. Just wanted to comment on
Okay.
the issue of daylight between our...
Oh, actually, so wait a minute, one second.
And this is a question for the CCSA recommendations on topics. Recommendation 4 about tracking the 3,000 megawatt net metering cap. I thought that was interesting to read that, and then also how important it is to developers as far as securing financing. I guess maybe for you or maybe for staff, I thought it was already the responsibility of the Public Service Commission to keep the official accounting of the 3,000 megawatt.
It is, and we do, and we will. I think what is perhaps wrapped into all of this is, what do we do when we get close? We need a procedure we can't like run over and go, oops, we ran over. And we also can't, we have to give some clear information to developers as to, is this project going to meet the cap or not when they do their plans? So I think
so it is or it is not our responsibility now at the Public Service Commission. This seems like an item that ought to be clarified soon.
We actually
because don't we also do that for the legislature to give them an opportunity to see where we are and whether we want to change something.
We have an annual report, which I'm sure you've seen, and one of the things that report does is track the increase over time over the previous year. But that's a once a year report. It takes data as of June 30th. Once we get closer, we are probably last time we were at like 1,100 megawatts statewide installed and operating. Once we get closer to to 2,000, we might want to say we need to have a game plan. It's not clear how fast we're going to reach that. The rules that have been proposed for you have a few things that are making an initial attempt to sort of put some early warning and give some direction to both the utilities and that the commission may, direct them to do something specific, like stop accepting applications once we reach a particular threshold that is below the statewide cap, but with hopefully sufficient spare room above that headroom to make sure we don't go over that inadvertently.
Okay. I just wanted to make note of that because, again, you confirmed that is a responsibility of the commission. So in that there are various consumers of this information, Mr. Chair, this may be something we want to be provide some more guidance if we're not giving the specificity that's needed now. So thank you, Mr. Chair.
Do you mind, Commissioner Richard? I might just add on there a little bit, which is that there are kind of two big aspects of the net metering cap. One is what's next, what happens after that 3 gigawatt world. What we were focused on in our comments was more from the community solar perspective, because the community solar projects, as we've been talking about, are on a much longer development timeline than a residential rooftop solar system or even a commercial rooftop solar system. And so right now, the net metering cap, it just says operating, once 3 gigawatts are operating, that's it. But from a development standpoint, that's a lot of millions of dollars potentially you're investing into a project, not knowing if you're going to be at that 3 gigawatt line or 3001 or 2099. And so what we're kind of suggesting is that community solar, probably all net metering in general, but community solar in particular, for our own interests, we're concerned about wanting to know kind of when are you sort of awarded capacity and can confidently move ahead and start building that project. You don't want to have two projects kind of trying to build, racing each other to get into an operating condition first. So there's a little bit of a unique concern that we have for the community solar industry there.
Okay, thank you. No, I agree that we need to have some precision on this point.
Okay, so let me sketch out a path forward here. We're going to take this under advisement, and we are going to be issuing a written order or orders. And what that may be is we will potentially issue an order dealing with TPE's specific request for a waiver as soon as we can. But it may also be incorporated with an order discussing a waiver process in light of the determination of the rulemaking. So as we get together and sort of talk about this, we may do them as a joint order, or there may be two separate orders, but we're going to get it out sooner rather than later. And we'll have something for folks in the short term. So anything else? All right, with that, we're adjourned. Now, we have a rulemaking on the cybersecurity issues, but I need to take a break. And I understand the cyber people have been waiting around patiently. So why don't we start the rulemaking for that at 12:15, and then we'll